there, this is Erica Merrill, and I'm the founder of Perfect Legal Video. I have with us today attorney Jim Sorensen of the Sorensen Van Leuven Law Firm out of Tallahassee, Florida. And they work specifically with credit unions. And I want to welcome you today, Jim. Thank you so much for coming on the show.
Thank you, Erica, for having me. Looking forward to being here with you today.
Yes, of course, as usual. So today we're going to be doing an update on the CFPB and their new debt collection rules. And we're going to find out from you a little bit about those again, a little bit of a reminder, but then we're going to talk about how things are going and just make sure that the credit unions that are watching this have some really good tips and advice on how to handle these new rules. So let's start off with just talking about what has happened to the proposed rules.
Okay. Well, the CFPB had issued last year a proposed rule. We've talked about it in a prior interview, and they have now issued their final rule. And that final rule takes effect next year, November 30th of 2021. So this rule has now been published and released, and we have just a little bit under a year now to get ready for it and be ready to for its full implementation.
So what is the aim of this new rule?
Yeah, I think the aim could be boiled down to this. I mean, the rule was put in place to protect the consumers from abusive debt collection practices. And it's also to protect the consumers' privacy rights, to protect their privacy, so that it's not public information that they're struggling to pay their bills.
I mean, that makes a lot of sense. And you do sometimes you hear bad things about what happens with debt collection. And I know that it's always just a few bad apples that spoil the whole bunch, because honestly, to stay in business, you have to have debt collection. You just do, or else your banks and your credit unions and your businesses, whoever they are, if people owe you money and you can't get paid, then you're going to go under. So with this in mind, you said that this was mostly to protect the consumer. So who is subject to the new rules?
Yeah, so the new rules that go into place are aimed mostly at what we call third-party debt collectors. It's people who are collecting debts for other people. They aren't the original creditor, they're not the original lender, but they're collecting the debt for somebody else. And it also is directed at what we call debt buyers. These are companies that buy defaulted loans with the idea of collecting those loans. They didn't originate them. They don't have the original relationship with the consumer. And those are the two main, if you will, groups that this rule is aimed at.
Will this affect credit unions in any way? Are there any applications or limits that are going to be applied to the credit unions?
Yes, I think it's going to be more indirect than direct application or impact to credit unions. First of all, if a credit union hires a debt collector, they hire a debt collector to collect debts for them. That debt collector will have to comply with this rule. And the credit union needs to take that into consideration and make sure that debt collector is ready to abide by this rule, or in the future, after November 30th of next year, that they are complying with the rule. The other part of it is the rule establishes some requirements or specific ways that technology is to be used in debt collection. And the question becomes, does that set standards that will then apply to creditors as well? And if it does, then it applies directly to the credit union. So that's something we're going to have to wait and see.
I see. So And I agree with you. I know that there are a lot of rules, and they definitely have different ones that apply to the different modes of communication, and they seem to be getting more and more strict with some of those rules. So what I hear you saying is sometimes credit unions will outsource their collections, and so they are really going to be held responsible for what another company is doing on their behalf. So, with that in mind, how would a credit union take steps to assure that that debt collector that they hire complies with the new rules?
Good question. I think, the credit unions need to understand that when they hire a debt collector, they're acting as their agent. And so they need to be assured that in their due diligence they do on that vendor, and this is true whether it's an existing vendor or a new vendor they're looking to hire, that vendor, that debt collector, has proper practices, proper procedures in place, and the staff is trained to comply with these rules. Again, we've got right now about 11 months to comply with the rule, but these debt collectors have to start putting those practices and procedures and training in place. The second part of this is, I think, when you go to hire a vendor who's a debt collector, you want to make sure that they aren't currently under investigation from the CFPB or some other applicable government agency as having engaged in questionable practices. Um, you want to certainly look, and I think it's worthwhile looking at the CFPB's database. They have a complaint database that any consumer, anybody can go to, and you can search a particular company, whether it's a creditor or debt collector or some other companies that they uh, have direct oversight over, and you can see what complaints have been lodged against that company, and you can get an idea of the volume of the complaints and the types of complaints, and that tells you something. If you see a vendor out there that has a lot of complaints, and that starts to raise a red flag, and something would tell you need to do some more due diligence. And then finally, the credit union, in engaging these vendors, they have a contract, and their contract needs to be drafted such that the debt collector they're hiring is obligated to comply with the rule. And if they don't, that any risk or blame or liability is shifted to the debt collector. It doesn't come back and hurt the credit union. So those are all the steps that we would be advising our clients to do when they engage a debt collector in light of this rule.
Sounds a little like dating when you see those red flags. Run, don't
Sort
run.
of like dating.
You want to ignore the flags. You want to just be able to trust somebody, but honestly, you really do have to do that due diligence. So I think that's really great advice, and I know that you take care of a lot of your clients and helping them spot those red flags.
We try to, and certainly, sometimes we will have seen things with a particular vendor that we can alert our clients to, and give them a heads up on potential red flags.
Yeah, no, absolutely. You heard that your cousin dated that guy once and he didn't treat her well.
Exactly. We kind of serve in that regard sometimes.
Absolutely. Well, for the folks out there watching, we really do mean creditors and debt collectors here, but it's a fun little analogy.
It
So can
is.
you tell us a little bit more about the rule itself?
Yeah, so the rule can really be broken down into two basic parts. Um, Part one deals with just general rules on communicating with a consumer. So these are general rules that apply to any form of communication. And then part two of the rule deals with specific rules that deal with specific mediums of communications or specific ways of communicating. So, for example, there are specific rules that deal with texting. There are specific rules that deal with emails. There are specific rules that deal with telephones. So that's really how the rule is broken down. You've got the general rules that apply to all communication, and then you've got specific rules to specific types of communication mediums.
Are there any significant limitations when it comes to communications?
Yeah, when you look at the general rules that apply to all communications, for the most part, these rules are not really that much of a change in the law. Um, the one exception is there's a limitation on continuing to communicate with a consumer who refuses to pay. Under the rule, if a consumer states in writing that they are refusing or they refuse to pay the debt, um, at that point the debt collector has to stop all communication. Otherwise, it's deemed harassment. It doesn't mean that legal action can't begin. It doesn't mean they can't be sued and can eventually have their wages garnished or something like that. But the communication of, hey, you need to pay this debt ends. And that's the most significant change in the general rules that deal with communication.
I heard you mention a few of the modes of communication just in our general conversation here. I wonder if you could go over them each specifically just to so that we know all of the ones that we're talking about when it comes to this new rule.
Yeah. So under the new rule, when it addresses really three modes of communication: email, text messaging, and then telephone. And so there are specific rules that deal with email, specific rules that deal with text messaging, and specific rules that deal with telephone.
And I think that like why that's important. There's always call centers out there and there's just a lot of people working there, different shifts, people calling over and over. You've got to worry about how often they call, when they call. Are they rude? I mean, do they lie to the people? I mean, there's definitely a lot of interesting things that happen when people are collecting a debt, and I'm sure the rules will address some of that. So what are some of the limits that are, I just mentioned phone, but like, I guess we'll start with email because I know email is a really big one right now.
Yeah, email has been used in debt collection for a while now. And what's interesting is there really hasn't been a lot of guidance or rules on how to use email or what is allowed and what isn't allowed. Um, there isn't a lot of laws on this. There's not a lot of court cases on this. So it's been somewhat creditors using email kind of and debt collectors using email at their own risk. And so the rule gives some guidance. And one of the things the rule is concerned about, as I mentioned earlier, is consumer privacy. It's the idea that, and we all know this, email is not the most secure mode of communication. We know that email can be intercepted. Some people share email with a significant other. Or you can simply leave your computer unsecured and someone can access your email, whether it's a roommate or a friend, or you walk away from your laptop at Starbucks and someone looks over your shoulder. So the CFPB was concerned about that. And so what the rule does is it gives some guidance on when emails can be used, when it cannot be used. For example, you can't send emails to what is clearly a work email. If it's a Google email, if it's some other public email extension, the assumption is that's a public email you can use. If it's a work-based email, you can't use it. There's also opt-out provisions so that the consumer can opt out, and disclosures about the fact that email is not a secure communication. So those are the things the rules address as in regards to email communication.
I mean, I would imagine in court, I mean, does that even hold up if they say, well, we sent them 5 emails? I mean, you can't even really guarantee that they got it.
For that type of communication, email is probably not the way you want to go. But, a lot of these are just simply, hey, you didn't pay you didn't make your payment last Friday, or we need to talk to you about your payment, or we need to talk to you about your debt. So that's a lot of the context of these emails. They aren't necessarily legally required communications, but they're attempts to reach the consumer and have a conversation about the outstanding debt.
All right, well, that's helpful. I'm really interested to hear a lot more about what the regulations are around texting, because I believe that's one of the newest ways that people are communicating, and it really does cut through. Like, everyone looks at their text messages. They don't always look at their junk email or their email. A lot of those things can get forgotten. If you send something in the mail, that can get tossed, but people are glued to their text messages. So, tell us a little bit about how text messages falls under these new rules, and what people have to watch out for.
Yeah, I think you're exactly right. I mean, text messaging is really one of the newest or newer forms of communication that is used in debt collection, and there's certainly certain segments of the population that prefer it. Certainly the younger people prefer texting. Um, as you get into the senior citizens, maybe that texting doesn't work as well. But for a lot of people, you're right. I mean, text seems to cut through some of the clutter that's out there with junk email and junk mail. So we've certainly seen an increase in the use of texting, and the CFPB wanted to address that. So what the rule requires is generally that the consumer consent to the use of text to reach them via their mobile phone. Um, and then once they give consent, that consent is only good for 60 days unless the consumer gives a new consent or the debt collector verifies that the telephone number that is being used is still registered to that consumer. Mobile phone numbers can change over time. As you could switch providers and get a completely new phone number. You may end up giving your phone or phone number to a family member, a child, something like that. So in light of that, in light of numbers not always staying with people and numbers changing, the CFPB wanted to be sure that the texts going through were going through to the proper consumer. And so the rule was set up as, if I give consent, it's only good for 60 days unless the debt collector, in this case, can go into a reliable database and confirm in 60 days that the number still belongs to me. So that's how the CFPB has kind of addressed the portability of those numbers moving around.
That is difficult. It's funny too, because um, I used to be married to someone who had the same name as his dad, and like, I'll tell you, like, lots of things got confused, even though they didn't live in the same house, and they get just, you pull up a credit report and sometimes you get the wrong person. It's very interesting.
Yes.
There's common names out there, and everyone wants to have a family name, and that they've got to really be careful and verify that. I mean, you've heard about identities getting stolen and that sort of thing. Well, I mean, this is within the family, and it's just confusing as all heck for somebody trying to collect a debt.
Yep. That's exactly right.
So tell us about the one that everybody thinks about first when they think about debt collection. And that is, oh gosh, I can't even answer my phone anymore. They're calling so often. And I know that these rules are going to address that. Can you give us a little insight on, what they've done to improve the experience, I guess, for the people that are having the debts collected on them?
Yeah, so the regulation is aimed at providing some guidance on the use of telephones and to avoid harassing the member or the consumer. And this is just like you said. I mean, we all generally, most everybody I've ever met does not like getting unsolicited calls. And right now we all joke, and there's jokes everywhere about the car warranties, right? We wish this regulation applied to car warranties, but companies, but it doesn't. It applies to debt collectors. And what the rule says is that there is a limit on the number of calls in a week. The debt collector cannot make or attempt to reach by telephone more than 7 calls in a week, 7 calls in a week. So, in addition to that, once they reach the consumer, so if on Monday they call the consumer and have a conversation, hey, you know, do you realize you didn't make your payment last Friday, right? Oh, yeah, I forgot. I'll take care of it this week. The debt collector cannot call again for 7 days. So once they make contact, there's kind of this, if you will, waiting period. They can't call me every day. Hey, did you make your payment? Hey, did you make your payment? Um, and so those are the new limitations. They're both seven calls in a week. And then once you make contact with the consumer, no more calls for the 7 days.
I mean, I think that makes sense. And not only is it good for the consumer, but it's also good for the credit union because a lot of these people are paying their bills. They just got wrapped up and, maybe we all get busy and especially right now with everything going on. And sometimes, the one call is enough and they may get to it the next week when they finally sit down and look at all their bills from, whatever happened. And, maybe they had an employee that left and they just didn't get to the bills because that employee was supposed to pay that stuff. So, I mean, I get why they do that, and that way they don't annoy their clients that are actually just a little late and willing to pay, and then lose them because those people get annoyed and they say, well, the next time I'm just going to get a loan from someone that's not going to harass me for something that I absolutely intended to pay in a few more days, that kind of thing.
I think it. I think the clarity of how many calls is helpful. The law has always been you can't harass, but harassment is in the eye of the beholder. And so now there's some clarity, right? I know I can make 7 calls a week. And I know that once I talk to them, I can't talk to them again within the 7 day period. Now, that doesn't stop the consumer from calling the debt collector or the creditor. That doesn't stop the consumer from saying, hey, will you call me back tomorrow when I'm at home and at a place I can deal with this? So the consumer can always give permission, but this provides some clear rules on what is harassment and what isn't, which I think is always better than leaving it up to someone's interpretation and having to guess. So I do think in some ways it provides clarity to an area that doesn't always have clarity.
I mean, I think it's great too, and you're right. It's nice to have the number and what exactly is expected because if you can't measure it, you don't know what you're measuring against, then that's when all hell breaks loose. And
Yep.
people get in trouble and people lose clients and that that can be a real mess for your clients. So especially when they're hiring contractors sometimes to do the debt collecting, they want to make sure that they're representing them the right way and they're not harassing people.
Correct.
So, do you have any other advice for us today on the rules for the credit unions out there that are looking to abide by those rules and do the best that they can?
Yeah, I think my advice is these specific rules that apply to how to use email, how to use texting, how to use the telephone. As we discussed, these rules specifically do not apply to the credit union directly. But what they do is they start to establish this standard of what is harassment or what isn't, what is safe, what is best practices. And so the question that all credit unions are going to have to face over the next year is, do we start to abide by these rules, even though these rules don't immediately apply to us or directly apply to us? Should we start to implement some of these within our practice and the way we collect our own debts? Certainly, the debt collectors are going to have to do that, but does the credit union and its own employees start to follow these rules? And that is, there are several things to consider in that decision. and several things to think through. It also impacts state law, so this could be different in Florida versus Georgia versus another state. So, my advice is these are decisions that need to be considered with some specific legal advice, given the state the client's in, given the membership of the client, given the current situation of that client. And I'm just trying to encourage my clients to consider all these things now, so that if any of this is going to be implemented by next November, there's time to get it done. And so that's going to take some time, and that just, it's going to require each client sitting down with their lawyer, each credit union sitting down with their lawyer and having that discussion. And certainly that's something we will be doing with our clients over the next several months. And certainly I would encourage any credit union who's listening to this, if you're unsure of how to approach this, reach out to our law firm, and one of the lawyers or myself can help walk them through that decision process and how to approach that.
Well, I think that's very helpful. And for all of the credit unions that are out there watching this, if you yourself need help, or if you know other credit unions out there that might have questions about some of these rules, I mean, the significance of having an attorney help you with this that is well versed in the laws and stay on top of everything that's coming out that's new, just like the Sorensen Van Leuven law firm does for their clients, is that, inevitably you're going to save a lot of money on getting sued later for doing the wrong thing. I mean, I think that that's one of the biggest um, things that people get from using an attorney and using an expert. I mean, have you seen a lot of gotchas that you've been able to clear up for your clients before they get fined?
Yes. Oh, yes. And I think, it's like good preventative maintenance. It's just like changing oil in your car or putting new tires on your car. When you run a credit union, and specifically when you're dealing with a collection department, there are certain preventative maintenance that has to be done. And if it's not done, you're going to pay that price elsewhere. And a lot of times it's significantly more. To use the analogy of changing oil, it's not that expensive to change oil in a car, but it's something that has to be done on a regular basis. If you don't do it, you're going to face replacing the engine. Well, the same thing here. If you don't go through and do the preventative maintenance, you could face a significant lawsuit, and you could be talking about six figures or more, if it's a bad enough situation. And certainly that's part of what we try to do is keep our clients from facing those lawsuits, or the government investigating and coming in and trying to tell the client how to run their business. So this is all preventative maintenance that we try to do for our clients.
Yeah, and the thing that I love the most about your law firm is that you've come up with programs where you can help the credit unions train their staff on a regular basis, because they've got turnover. I mean, you don't keep the same employees for their whole lives. And even then, when you train somebody, you really do need to go with the car analogy, tune-ups, to make sure that everything's working correctly. Because if they send out one wrong letter and it says the wrong thing, and then they send it out to hundreds of people before you find out, and the reason you find out is because somebody sues you, and then all of a sudden you've got lots of other lawsuits coming in, you're right, that could be hundreds of thousands of dollars. And in fact, it could be the reason that a credit union goes out of business. I mean, they're just like any other business. Sometimes people think that they might be infallible because of what they do, but they can go under for making mistakes just like any other business.
They can, they end up, when difference with a credit union going under is because there is the government guarantee of the underlying deposits. Usually that credit union gets absorbed by a much healthier institution, so the credit union goes bye-bye, but the customers are okay. And in certainly in bad situations, that can be the result. And so we're all about the preventative maintenance. We're all about trying to, make sure that our clients understand the risks and understand all the issues and are making informed decisions as they continue forward.
I mean, that makes sense. And they surely are lucky to have you. So, yeah, I want to thank you so much for coming on here and helping out with this education for credit unions, helping keep them abreast of the new rules that are coming out. Um, it's just fantastic. And we're looking forward to hearing from you again. I know that you have a lot of topics coming up in the near future, and we'll get those out as fast as we can.
Thank you, Erica, for having me, and good to talk with you.
Thanks again. We'll see you soon.